Thank you all for being here today. We really appreciate you coming out for this important announcement. Today, all of us here are excited to announce an important and really a historic victory for Washington workers at the Hanford Nuclear Reservation. It was almost exactly 3 years ago this September, that many of us who are here today were here 3 years ago to announce that a lawsuit was being filed against the federal government regarding the lack of protections for workers at the Hanford Nuclear Waste Site. The many reports of workers getting sick there are well documented, in some cases by many of you. As a result of that lawsuit against the federal government seeking better protections for workers at Hanford, the United States Department of Energy will, under an agreement that we're announcing today, be moving ahead with a system that, if successful, will for the first time capture and destroy toxic vapors that escape the nuclear waste tanks and pose such a significant danger to workers who clean up the site. This is the result, and I want to emphasize this, of a true team effort with our partners Hanford Challenge, who are here today. I'll be making introductions shortly, and UA Local 598, the group that represents the men and women working at the tank farm, as well as individual men and women who work hard at Hanford and were willing to step forward and have their voices heard to challenge the federal government on this important issue. So I'll do a few introductions. We'll have a few more introductions a bit later on as well, but I'll start with some key folks from my team at the Office of the Attorney General who are here today, and a couple of whom will help answer questions that you may have about the agreement. So in no particular order of importance, but Assistant Attorney General Kelly Wood of the Council for Environmental Protection. Kelly is right behind me. Senior Counsel Andy Fitz of our Ecology Division. Andy, you've seen before at these press conferences. Division Chief Laura Watson, who heads our Ecology Division. Laura's here in the back row. Assistant Attorney General Caroline Kress, who's also with the Ecology Division. Unit Chief Bill Sherman, he's the head of our Council for Environmental Protection. Also joined from Hanford Challenge, someone many of you know is Tom Carpenter. Tom, there in the back row. Look, I'll just say Tom and I have gotten to know each other well the past several years, and he's really, as his whole team is a really effective voice for his organization and the workers at Hanford. Also from Hanford Challenge, immediately to my right, is their attorney, Meredith Crafton. She'll be speaking and giving some remarks after I speak. And to Meredith's right is business agent of UA Local 598, Mark Mokler. Mark will be speaking after Meredith. So the three of us will have some prepared remarks before we take your questions. I also want to introduce two other very important people who are here today. To my immediate left are Abe Garza and Bertola Garza. Abe has worked at the tank farms, has been impacted by that work as part of the lawsuits that were filed and joined together, filed a declaration lending his voice to that lawsuit. You know, as I often say to my team, look, our job is to compile facts and put the law together, but you know, a lawsuit is, in the end, a story. And the story in this case was always pretty clear. Sometimes you got to think through what the story is, but in this case, the story was pretty clear, and that is the impact on Hanford workers due to the federal government's unwillingness to put in place the protections that those Hanford workers deserve. And Abe is an example of that, and so I'm so excited that the two of them are here. And they have family members, I think a grandson, is that right? Yes. A grandson who is a young man in his 20s who is working at Hanford, and they will not be having prepared remarks, but they are prepared to answer questions that you may have either here after we're done speaking or one-on-one afterwards as well. But we were just chatting beforehand about, they both mentioned the importance of these protections for current workers, but also next generation of workers at the Hanford Tank Farm. I'm going to provide a summary of what today's agreement is, a quick history of how we got here, and then some more specific information about the agreement. For the first time, the U.S. Department of Energy agrees to do the following, and these are the steps outlined here on the information board to my left. So first, they will for the first time test new technology that actually captures and destroys the dangerous tank vapors there at the Hanford Nuclear Waste Site, and, if successful, to implement that technology. Number two, to maintain the interim safety measures currently in place, including supplied air and respirators, to keep workers safe during testing. I'll have more to say about that in a little bit. They also agreed to install a vapor monitoring, detection, and alarm system in the areas where vapor exposures are most likely to occur. They also have agreed to improve transparency of information regarding vapor events, worker protection, and worker health. In addition, they will pay Washington State and Hanford Challenge. The federal government will pay Washington State and Hanford Challenge a total of $925,000 to reimburse us for our costs and fees for having to bring this lawsuit in the first place. I want to highlight that today's agreement does not end our lawsuit. Rather, it puts our lawsuit on hold. That's often different from a typical settlement agreement where you formally end the lawsuit, you dismiss it while the agreement's in place. That's often the case. That's not the case here. The case is effectively still in place, but we put a hold on it. And the case is on hold while the Department of Energy, completes their obligations that I just outlined, and there are more details of those obviously, while they complete their obligations under the agreement. If they do not meet their obligations under the agreement, we can renew our lawsuit. We have to start all over. That lawsuit's in place. It's in federal court, and we can move forward with it. Hanford workers have an important and challenging job. Those workers deserve to be protected while they perform that work. Hanford is a federal site. The Department of Energy and the federal government oversee the site, which means that it's their responsibility to keep workers safe. It is also Energy's duty to clean the site, and they need to ensure that workers are safe while also cleaning up that site. They need to do both. Yes, they need to clean it up. They need to clean up on a schedule, but they need to do that in a way that keeps workers safe. As you know, the Hanford Nuclear Reservation is located on the Columbia River near the Tri-Cities. The site was used to produce plutonium for the United States nuclear weapons program from 1943 till the mid-1980s. Production of weapons for World War II and the Cold War left behind large amounts of solid and liquid chemical waste, much of which is radioactive. The nuclear waste is stored in approximately 177 underground tanks at Hanford. They currently hold more than 50 million gallons of waste. The tanks at Hanford contain approximately 1,500 different volatile chemical gases. Many are highly toxic. These gases, or vapors, often leak from the tanks, and this is what workers are exposed to and have been exposed to for a long time. So sometimes we talk about the tank farms, we're working at the tanks. These are the workers who work at the tank farms. These vapors get released from the tanks, and the workers are exposed to them and have become ill. And this has gone on for many, many years. Studies by the Department of Energy, the federal government itself, by the Department of Energy and other government agencies found that exposure to these vapors can make workers sick. Workers have reported headaches, burning skin, dizziness, and nausea after vapor exposure. Some have had permanent loss of lung capacity. Exposures can also include lung disease, nerve damage, and several forms of cancer. Despite all that, the federal government resisted doing what every other industrial facility in Washington State is required to do: put protections in place that capture or destroy these chemicals before they reach workers. That's the obligation that a workplace has. This agreement that we're announcing today ends that resistance and places Energy firmly on the path to developing and implementing game-changing treatment technology. Unfortunately, it has not been an easy road to get here. So in September of 2015, the organizations I mentioned earlier, we sued President Obama's Department of Energy over worker safety. Workers have been getting sick for years. I think talking to Tom beforehand, you said you started working on these issues in 1997. This is going on for a long time. But Energy still, and look, there is no way to sugarcoat this. They did not take it seriously. There were 19 studies in approximately 20 years about this issue. Many of the experts who looked at this issue were the federal government's own experts, and the conclusion was consistently the same. Workers are getting sick, and that sickness comes from those vapors. For example, in 2014, just to give you a recent example, the Department of Energy, the federal government, commissioned a panel of experts to study safety at Hanford. Their report determined that, I'm quoting now, ongoing emission of tank vapors, which contain a mixture of toxic chemicals, is inconsistent with the provisions of a safe and healthful workplace free from recognized hazards. That's the federal government's own experts that they asked to take a look at the situation. The panel went on to cite that the data, quote, strongly suggests a causal link between chemical vapor release and subsequent adverse health effects experienced by tank farm workers. 6 months after we filed our case, nearly 50 additional workers were exposed to vapors. That was a major event. We then sought a preliminary injunction, asking the court to immediately order Energy to implement enhanced safety and monitoring measures. Only then did the federal government implement improved safety measures such as supplied air at the worksite. Supplied air is similar to a scuba mask, for example, and air tank. Other respiratory protections were also put in place. They did not have these protections in place until we filed our lawsuit, and more specifically, filed our motion for a preliminary injunction. After they implemented those temporary changes, the federal government, it should be pointed out, tried to have our case dismissed. They went to court to say, hey, this case should be dismissed. They actually argued to a federal judge that as Attorney General, I did not have the authority or the ability to bring a lawsuit on behalf of the workers at Hanford, and one of their arguments was not enough workers were getting sick for me as Attorney General to have standing, to have the authority to bring the lawsuit to the federal judge. Fortunately, in November 2016, the court agreed that we could bring that lawsuit and denied the federal government's request to dismiss the case, and that allowed our case to move forward. But that interim measures that they have, that supplied air, while it's been helpful on a short-term basis, that is a temporary solution. So we were scheduled for trial coming up next year. So again, today's settlement puts our case on hold, but it does not dismiss it, while Energy does certain things. Again, they're going to pay $925,000. We'll share that with Hanford Challenge. And they're agreed to the phased testing of new technology, again, to capture and destroy those tank vapors. That's important here. Not just have protections when the vapors come out, but to destroy and eliminate those vapors in the first place. They're going to install, and if successful, to implement those changes. Install a vapor monitoring detection alarm system, where these releases are most likely to occur, to keep those current safety measures in place. So while all this is going on, that testing, that implementation, the supplied air stays in place for those workers to keep them safe while they're working at the tank farms. That stays in place while that testing of new technology goes on. And of course, improved sharing of information on these issues. The most promising technology, we believe, is a treatment system created by a company called Nucon, N-U-C-O-N, Nucon International. Their treatment system can capture or destroy hazardous vapors emitted from the tanks at Hanford. It is still in testing, but my team believes that so far the results have been encouraging. Energy must use this system to test on simulated tank waste by the end of the year. Then it will move to test on actual tank waste at Hanford. If that goes well, we then move forward on a timeline to implement the system at a tank farm. In addition to that treatment system, Energy will test a second system called Astrobic Air with a commitment to install it in a tank farm. This system would use a jet turbine to send vapors high into the air. At the end of this testing, the parties will come together to negotiate a timeline for installing controls across all the tank farms. And if we can't reach agreement, as I've mentioned before and I want to emphasize, we go right back to our lawsuit. That lawsuit's not dismissed. It stays in place. It's at the federal court. If I'm not satisfied with where this is going, we can go back to court. Bottom line is this is a major and significant win for Hanford workers. After years of dealing with these toxic vapors and hundreds of workers getting sick year after year, we are finally moving towards a lasting solution. I guess one thing I will mention is I'm sometimes asked, well, hey, Bob, what about the workers who have already gotten sick? You know, what can you do for them specifically? It's important to note from a legal perspective that I have the ability under the law, under the statute that we're using, to seek what we call injunctive relief, to make changes to create a safe work environment. I don't have the authority to go and get money, for example, for individual workers. If I did, we would have done that as well. So today we've accomplished what we set out to do with this piece of litigation, to create a system to protect workers. And if Energy complies, we should have few vapor exposures from now on, which means fewer workers suffering from potentially life-altering, debilitating health issues as a result of these exposures. It's also worth pointing out that a lot of legislators working with folks here passed a law at the last legislative session, which we did support, which helps enable those workers to get the compensation that they deserve for getting sick at the Hanford Nuclear Waste Site. That was well documented in the media, an effort we are proud to support, and the folks here really helped make that happen. Before I turn it over to Meredith and to Mark, I just want to say, look, we should never have had to file a lawsuit. It shouldn't have come to this. Year after year after year. And look, their own experts tell them what the problem is. Their own experts saying what they can do to fix the problem. It's our own federal government, right? And look, I often say, I speak about this case a lot, if someone's got a tougher job in this state than a worker working on the Hanford tank farm, raise your hand and tell me what it is. I'm curious to know what that job is. The federal government did not do right by those workers, to put it very, very mildly. It's hard for me to think of a case in my entire career that angers me more than this one. It's a bureaucracy that did not recognize what happened. If the workers out there at Hanford were the sons and daughters of members of Congress, it would not have taken a lawsuit to solve the problem. I take no pleasure in saying it, but it is a fact. If the Hanford Nuclear Waste Site was located in Northern Virginia, we would not have had to file a lawsuit. That is a fact. The good news is, working with groups like the union, like Hanford Challenge, we can use the law to make the federal government do what it needs to do and what it should have done in the first place. So it's been a huge team effort. Individuals being brave enough to come forward, organizations putting their muscle behind a lawsuit, which is not easy. It's been years of litigation to get to this point, to resisting even in litigation, the federal government fighting us and trying to get the case dismissed. I will say I am pleased the federal government finally agreed to resolve this case. I was, of course, prepared to take this case to trial, as my team knows. A big part of me still wants to take this case to trial. That said, and we talked about this many times together, this agreement gives us everything we wanted. There really wasn't anything more in a trial that we were seeking for workers, and therefore there's no reason to risk anything at trial. And so it's a great outcome, and I now want to turn it over to Meredith, who will speak next. As I mentioned before, Meredith with Hanford Challenge, and she'll speak next about this great outcome. Meredith.
Hi. Thank you all for being here. I'm Meredith Crafton. I'm an attorney with Smith & Lowney, and I represent Local 598 and Hanford Challenge. It's been my honor to represent Hanford workers via the membership of 598 and Hanford Challenge, and to work with Public Justice out of Washington, D.C., and Terrell Marshall Law Group with Blythe Chandler, who's also here. We have had a great team and have been really grateful and appreciative of the Attorney General and his team for taking on this very important fight with us and being willing to put so much commitment and effort into this cause that, as the Attorney General recognized, we've been working on for quite a while. So there's just a long history of worker exposure to toxic vapors at Hanford tank farms, and this alliance has changed the regulatory landscape at Hanford and specifically at the tank farms. And we've used an environmental law here, the Resource Conservation and Recovery Act, to support worker health and safety. And hearing and documenting dozens of stories of sick workers was heartbreaking. And this was constant motivation to fight this lawsuit. And we are appreciative of the Department of Energy for coming to the table and creating this agreement that brings commitment to protecting workers in the interim and also incentivizing technology that can actually capture and treat these vapors to stop these incidences of exposure to toxic chemicals from occurring in one of the most important jobs and missions of our state, which is securing and cleaning up Hanford's nuclear waste. So again, this has been, an incredible legal team using environmental jobs to provide protection for workers. This settlement was executed, today in hopes that we won't have to respond to additional exposure incidences. And, we appreciate Energy's commitment to that now, and we'll continue to hold the Department of Energy accountable and ensure that the agreed upon transparency and technology and development of additional protections for workers gets in place. So again, thank you, and I'd like to turn it over to Mark Mokler of Local 598.
Mark, before you come on over, I just want to say I've had the real honor to get to know many of the men and women who are part of Local 998 in the last several years. And look, the local does a fantastic job of representing and standing up for the folks, the men and women who work there at the Hanford Nuclear Waste Site. It's, I just have such respect for the work that Mark and his team do on behalf of those workers. So without anything further, Mark, go right ahead. Yeah, thank you.
Thank you for coming out today. I'd like to acknowledge our team from the local, Randy Wally and Jim Melbauer. They couldn't be here today. They had prior commitments. And Nick Bump is standing behind me. Mokler, M-O-K-L-E-R. The United Association of Plumbers and Steam Fitters, Local 598, will always stand firmly with the working people of the Hanford community. It is because of their commitment to this great nation, we the people of this nation stand freely in the world today. The men and women who give and have given their lives towards this cause cannot and will not be forgotten. We must continue to protect their health and safety if we are to endure our mission of cleaning up the site. The cycle of commissioning studies on Hanford's tank vapor problems has led to many key findings, but ineffective solutions with regards to the tank vapor exposure problems. The DOE would initiate a study, analyze the data, and wait for the negative effects of the exposure to settle down, and then attempt to move on. This path resulted in more vapor exposures, more health-related complications, and yet another commission study that didn't repair this dreadful sequence of events. The repetitive and predictable outcome of this replayed itself over 20 times. Optimistically speaking, this unsuccessful cycle of commissioning study after study appears to be jubilantly finished. The settlement of this lawsuit hopefully represents a positive step in ending this type of decision-making by our officials who are in charge of cleaning up the Hanford site. We believe we can now move forward with assurances from the DOE that the issues of tank vapors will be addressed and resolved. Our Hanford workers need an environment in which workplace hazards are eliminated so that they can complete their tasks with minimized risk. It is imperative to the success of the cleanup mission that this be achieved. The mechanisms of this settlement open the door and begin to pave the way for this accomplishment. Local 598 would like to thank Washington State Attorney General Bob Ferguson, his staff, for their participation in this case. Without their engagement, we would have never gotten to the place we are at today. Local 598 would also like to thank Washington State Department of Ecology for their assistance. Their expertise in all matters related has been invaluable. Local 598 thanks Tom Carpenter and his staff at the Hanford Challenge for their vigilance in watching and demanding that the DOE and its contractors make progress towards a safe and clean site for all workers involved in the cleanup. And Local 598 extends a special thanks to the office and staff of Smith and Lowney for their diligence and tireless efforts dedicated on behalf of this cause. Without their hard work and determination, it would not have been capable to arrive at this point and make this settlement a reality. And lastly, to the citizens of the United States, I ask you to communicate with your local, state, and national representatives. Ask questions that demand answers to mandate solutions to the ongoing problem of Hanford tank waste. We need to fix this before an incomprehensible disaster occurs. We cannot let our guard down until the last measurable amount of Hanford waste is safely processed into a stable and secure condition. Only then will the threat to our health and our environment be entirely removed. The people of Washington State should expect nothing less. Thank you.
Mark, thanks for those comments. And I think the phrase you used was of the last 20 years, repetitive but predictable, of how it's been, and which I think really captures how it's been. I've only been on this for a handful of years. Folks here a lot longer, but that is exactly what I saw as well, just repetitive but predictable response from the federal government over these last 20 years. I will say, while I've had some really hard things to say about the federal government on this issue, to put it mildly, they did ultimately come to the table. We do think, and my team feels, I think I can speak for my team on this, that they feel they've had a good dialogue with the representatives of the federal government to come to this resolution. It takes two. It takes all the parties to come together to sign an agreement, and so obviously the federal government, to their credit, did reach a resolution that all of us were agreed on, and that's no small thing. I mean, I think it's fair to say that what we wanted to see in any agreement before we would sign it had to be pretty detailed, and to our satisfaction, that bar was pretty high, and they did meet that. So I think it's only fair to acknowledge that. It just came after too many years and too many workers getting sick. Again, that's just a fact. You can't sugarcoat that, and they have to own that. So with that, we look forward to any questions you have, and feel free to address anyone in particular, or just open it up. Go right ahead.
Two things. One, do you have a number of the total amount of workers who have been exposed to vapors so far? And my second question is regarding, I want to see if I can get some elaboration on the vapor capturing and destroying technology. Essentially, you mentioned a couple companies. What specifically is the technology? When would the testing actually be done? And does the state or the plaintiffs have a deadline saying, we want this thing fixed before we resume the lawsuit?
I think that was a 7-part question or so we'll do our best to answer. So we'll start. So my team will help me sort out particularly the second one where there is a list. But I think those are all good questions, and we'll do our best. So I think the first question I heard was the number of people, workers who we think have been exposed. Does anyone want to take Tom? So this is for those on the phone. This is Tom Carpenter, who will be answering the first piece of the question. Then we'll turn to the agreement, the technology, where things are going.
So we documented many hundreds of workers who have suffered vapor exposures to the extent where they reported for medical evaluation. So depending on how you report an exposure, this is how you answer your question. A number of those folks have suffered, I guess what you would say, irreparable harm, have gotten, sick to the point where, they've gotten compensation, either from the federal compensation system called the Energy Employees Occupational Injury Program Compensation Act, or through the worker comp program. I don't have a number for that, but it's been going on quite a while. We suspect the number of exposed workers over the years of operation at Hanford is actually in the thousands, if you want to go back to the 50s and the 60s, when lots of chemical vapors were coming out of these tanks. It wasn't even on anyone's mind. So a lot of injuries and illnesses have resulted from working at the Hanford site. The last I checked, the Department of Labor had paid out $1.5 billion for workers at the Hanford site because of illnesses resulting from working at Hanford. And many thousands and thousands of workers have gotten such compensation.
And then on the sort of the second piece that had some sub questions, I think so. So Andy Fitz is going to, I think, answer that. Is that right? So this is Andy Fitz from my office. Andy, go right ahead.
Yeah, Andy Fitz, Senior Counsel with the Attorney General's Office. So there are two different technologies that are going to be tested in phases. The first is what's the NUCON technology that Attorney General Ferguson referred to. And it's a combination of two things. It's a combustion process to basically burn up volatile organic vapors, and then a carbon filter to capture constituents that aren't destroyed by the heat. Principally, different forms of mercury are what we're really looking for with that. It's something that's actually widely used in commercial application with especially cleanup sites where you're extracting contaminated groundwater, for instance. The challenge here is utilizing it in a tank farm where you have mixed radioactive waste and hazards associated with that. So the phase testing is to make sure that it can be done effectively and safely. We have some performance measures that we've outlined in the settlement agreement to provide a bright line bar as to what they're trying to shoot for. And although we don't have a prescribed end date for that testing process, we do have provisions for those dates to be identified at certain points along the line. And the working presumption is that it'll be wrapped up by March of 2022. The second technology is called Strobic. This is essentially, it's applied in places in downtown Seattle where you have parking garages. Basically gathers up air and shoots it high in the air. It dilutes a bit in the process. We're less excited about that because it doesn't actually capture or destroy the constituents, but we do think that it's something that should be tested out, and it could even be used in conjunction with the treatment process. There is a firm deadline by the end of, end of November of 2018 to complete phase 2 testing of that, and if that's successful, to install it by 2022 in a tank farm.
Why so long between 2018 and 2022?
I think some uncertainties with how to configure it in the right farm. There's some space limitations to be worked out. There's also a permitting process that the federal government will have to go through with the Department of Ecology.
And you can ask energy, of course, but do you have an approximation of how much that will cost?
I do not actually.
And just on the question of cost, I'll just say that, look, everything costs money, right? But it is the obligation of every employer to provide a safe work environment. There are costs associated with that, and that may be particularly acute at Hanford Nuclear Waste Site, but it's our expectation they will absolutely find the resources to put this together. Look, the technology may take some time, to your earlier question, but again, the supplied air remains in effect throughout this process. And again, they've never agreed in the past to any sort of testing or implementation of using technology, again, to eliminate these vapors at their source. And that's the key here. We need to get that to happen. That's not going to happen tomorrow. It's not going to happen in a week. Believe me, I wish it was faster, right? But there are realities that we have to work with and accept. The key, again, at least key I can speak from my standpoint was, and I'm sure for everybody else was, while that's going on, workers still remain on that supplied air, which folks have worked really hard to make sure we're in place after we started that lawsuit. That was not in effect before we started this lawsuit. So the workers at the tank farms have that supplied air, keep them safe, while this technology, this process goes forward. Let me just give someone else, yeah, go right ahead.
Could I ask a question of Mr. Garza?
Yes, Mr. Garza, Abe, come on up. Come right on up. So for those on the phone, this is Abe Garza, and I'll repeat the question after it comes in.
I just wanted to hear how you've been affected by the vapors issue and what your reaction is to this settlement.
And the question is just how he's been affected by working at Hanford and how you feel about the resolution.
Well, I think this is a good thing for Hanford workers. As far as how I've been affected by it, I've had a lot of health issues in the past since 2010, well, even before that, and it's changed my life. And I just hope it doesn't happen to other workers out there. So I think what they've done here, I think, is a good thing. And hopefully that more Hanford workers do not get sick.
Do these provisions sound promising to you?
Yes, they do. I think it's time that Department of Energy faced up to the fact that people are getting sick, and they're, instead of trying to deny it, in my opinion.
What was your job there?
I was an instrument technician, yeah.
Can you repeat that?
Instrument technician. I'm sorry, my throat's, that's one of the issues I've got, so.
Mr. Garza, what is it like to work with the supplied air? I'm assuming that's been an adjustment for you.
It's difficult. You have a 90, 100-degree weather out there. You're wearing the Scott pack on your back, and you have a mask on your face, and then besides that, you have your SWP clothing over that. So you have modesty clothing under that, and you're all taped up, and they call them whites. You have whites over that. And so when it gets that hot outside, it doesn't take very long before you just, your mask is just full of perspiration. And it gets difficult to work out there in them kind of conditions. And people honestly want to get the work done, and they try to get it done as quickly as possible, but but sometimes it's just too demanding, especially when the weather gets hot. Yes.
Yes, Essex.
You mentioned the long years of resistance
Mhm.
from the federal government. What changed?
Excuse me. What changed in terms of with the federal government? Is,
Yeah, you mentioned they had resisted for more than 20 years. Now there's a settlement. What changed to end that resistance?
well, I mean, I have my thoughts. I can't say empirically, right, Essex, right? But I can share my thoughts. Others may want to share their thoughts as well. Combination of things. In no particular order of importance, right? Combination of things. One is there has been sustained pressure on the federal government. We mentioned how long folks like Hanford Challenge and others have been working on this issue. Number two, increased media visibility on the issue undoubtedly helped. You know, number three, a lawsuit focuses the mind. A lawsuit does not solve every problem in the world, right? I'm aware of that. Every day I think about that. But, a lawsuit focuses the mind. You've got deadlines, you've got obligations, you've got to provide documents, you've got to appear before a judge, you've got to answer questions, right? And there's ultimately an accounting in a courtroom for a federal judge. And, you know, candidly, I think the federal government wanted to avoid that day. They tried to avoid it, motions to dismiss, you name it, right? But that day was drawing closer all the time. And a big part, we knew going into it, the fact that it took a few years, look, when we were here talking 3 years ago, this is not a surprise. I don't think it's, we're disappointed it took 3 years, but I don't think anyone is surprised by that. And that we felt there'd be resistance, there was. But I do think that is, you know, the power of the law, right? It does force a reckoning at some point and an outcome. And so I think a combination, this is just my thoughts, right? I think a combination of those factors and others, individuals like Abe being willing to sign declarations saying, here I am, here's what's happened to me, here's why it's happened to me, here's the impact on my life. Look, that's, you know, that's powerful. So I think a combination. Anyone else want to add anything on that? Okay, yeah. Yeah.
For Tom Carpenter, Tom, when did you first get involved in this, and can you kind of go over the arc of what kind of response you got from ecology, from energy
Mhm.
at the get-go, and how that might have changed over the years, and what first began this whole thing?
Repeat that question a little bit, Tom. Is that right?
Okay, so the question was, you know, when did we first start working on this, and what is the arc of the response? And so I've been working on Hanford since the late 80s with workers and whistleblowers. The issue of vapor exposures first came to our attention in the early 90s. And because of a number of whistleblowers that came to us from the Department of Energy, actually, we wrote a report in 1997 that we kind of snarkily entitled Blowing Off Safety at the Hanford Tank Farms. And it documented what was happening with just one nuclear waste tank, the C-103 tank back then. And that report got a little bit of attention. It for the first time documented that internally the Department of Energy and the contractor and the scientists at Hanford knew that some of these chemicals carried with them severe risks, as much as 1 in 10 cancer risk. So we put that out there. You know, Hanford was not happy with that. And, you know, the response was, okay, well, let's put people on supplied air. And they did that for about 6 months, and then things went back to normal like they did. In 2002, we were approached by some more workers, some electricians actually, complaining of the number of exposures they kept happening, which resulted in us doing an investigation and talking to numbers of workers. We documented 86 exposures requiring medical attention in a 1.5 year period, and wrote a report that was mostly citing Department of Energy and contractor materials that had been provided to us. And we issued that report in 2003. It was called Knowing Endangerment, which is actually a phrase borrowed from the environmental laws saying if you handle hazardous waste, you cannot knowingly endanger, people. That report got amplified by the Attorney General at the time, who was Chris Gregoire, who ordered her own Attorney General staff in the state of Washington to investigate, as well. And that kicked off Department of Energy and other investigations. So I guess there were 3 investigations came together, and that resulted in supplied air actually being required for about a year and a half. And then they started taking it off as new managers came in and new people from the Department of Energy. And so we put out another report in 2005 called Systemic Injustice that said, here's a system that attempts to deny workers compensation because of these vapor exposures. And we, at that point in time, we had a concerns council, which was trying to mediate issues and problems at the Hanford site. We entered into a set of agreements with the concerns council and the contractor that they would undertake and put in place a number of remedies and rights for Hanford workers. That was respected and followed for several years. The vapor exposures went down. New contractor came in because that was CH. A new contractor came in, WRPS. All that got tossed out the window, and we started having these exposures again. So in 2014, in the spring, a whole bunch of exposures happened that were pretty severe, and that led us to, having talks with the union, UA 598. And Pete Nicasio, the business agent at the time, called me up and said, Tom, we got to do something about this. And that's when I wrote a letter to to Bob here, and which he responded to and said, yeah, we got to do something. So we started monitoring that situation in October of 2014. This independent report was put out called the Savannah River TVAT report, Tank Vapor Assessment Team. And I don't know what they thought was going to happen with that report, but it knocked our socks off because it said there's all these problems that you guys have been denying for all these years, and all these people are getting exposed and you're not doing anything about it. Well, it's the same kind of report that had happened over time. And at that point, we resolved that it had to end. So to kind of answer S's question earlier, it took a lawsuit. And then it took witnesses and the real deal, right? It's like no more evasions and no more pretending like it's not happening. We're putting it down. We're going to go to a court of law, and we're going to make this happen. And that's, I think, what changed, led to this agreement.
Does anybody know the component companies of WRPS LLC?
Washington Group was one, and Washington Group and Energy Solutions, and it's its own company now. But AECOM, I think, now took it over. AECOM is this big kind of engineering firm that is itself probably a conglomerate. So I think at this point, WRPS is owned by AECOM, AECOM.
Have you heard of URS or something?
Yeah, URS also got acquired by AECOM. Well, did they? Who did they get acquired by? And it's just hard to keep track these days. But yeah, URS was also out there. Yeah, they're also AECOM. That's right. So they kind of gobbled up some of these companies. Yeah.
I want to give a chance for, if there's anyone on the phone who wants to answer the questions. Dan, do I need to do anything to okay, great. So sometimes it can be complicated, folks on the phone. Sometimes it's easy to talk over each other, but if someone on the phone would like to ask a question, if you don't mind identifying yourself, and we'll do our best to answer it. If not, we'll get off easy from the phone lines. Any final let's see, Susanna, let's take maybe a couple more, but and we're happy to, everybody here said they're happy to stick around and take questions, obviously one-on-one with folks as well, but let's take a couple more. Susanna?
I have 2 questions, Bob.
Okay.
One is, since the tripartite agreement, there's been lots of legal action the state of Washington has been involved in with Hanford.
Mhm.
How would you characterize this one, and the settlement that's come from it? How would you characterize it compared to the rest of the actions that have been taken in terms of really changing the culture there, which is obviously been a huge problem?
It's kind of a hard question to answer, Susanna. So the question is, just to repeat it, I probably think about my answer, right? The question is, it's a good one. Is yeah, no, it's a good.
This
Yeah.
agreement and what's taken place here today,
Yeah.
in
No, it's a good question. So the question goes to how we characterize the outcome here today, and I think in the big picture, I think you were saying, hey, in terms of moving to change the culture at Hanford with the federal government, others should feel free to chime in as well.
I really feel that
This is
one of-
yeah, but so this is
Yeah.
Bertola, who's going
Mine-
to
yeah.
just step right up to the microphone, Bertola. They can hear you.
There's been several steps, but I also feel like everybody that's been up here, but I also feel Susanna has played a real important role in keeping all of this in the front lines and putting faces to the injured workers, and their stories has been phenomenal in helping that. But I think one of the questions is what is different. I really feel the first thing when I saw these guys working was, for once, the workers are being heard. And not only heard, but now there is steps to correct and to prevent further workers being injured. And I think that's critical. I think it's critical for the people that continue to work there. It's critical for the future workforce that is going to be there probably for a few hundred years more in monitoring and processing. I think, to me, that has been the biggest part, that finally they have came to terms to sit down and negotiate and have plans and actual equipment that will prevent with further injury with the vapors. The vapors are very critical, and like my husband, he did work out there for a long time, but that last vapor inhalation he had, he's lost 76% of his lungs. He got toxic encephalopathy, peripheral neuropathy, heart issues, and it kind of just goes on. And that is very important, so future workers, that does not happen to them. And I feel like all of these procedures that have been put in place, and a lot of excellent workers and a very strong Attorney General to put his foot down and help the workers that live in his state, has been critical.
Thank you, Bertola. That says a lot. I think what I would add to that is, when it comes to the culture, which I think is a really important question, which is why I'm thinking about my answer a little bit, is, look, it's difficult, to put it mildly, for any of us to change the culture of the federal government, right? To me, it's a hard thing to say. It's a culture of indifference to worker safety, of workers like Abe. It's heartbreaking to hear all the list of, right, the health challenges, right? That's, breaks my heart, right, to hear that. What other word can you use to describe it? What other word is there other than indifference? And so, change the culture. It is my hope, I don't think I can use the word expectation, but it is my hope that these stories, this litigation, this outcome will drive them to change that culture. I can't speak to how confident I am. What I can say is that I'm confident all of us here will make sure that the federal government honors every obligation they're signing on to today. We're going to make sure they do that. If not, I can assure you we'll be back in court, and I'll be far less likely to agree to any resolution short of a day before a federal judge. That is for sure. This is their last best shot. Okay, no, their last best shot, and so you will see, how that shakes out. But it's. I often say when speaking about this case, when I speak to a Rotary Club somewhere around the state, imagine it's your son or daughter working out there. How would you feel if this was going on, right? Repetition, but no surprise, right? Right? Over and over again, nothing changes. And so we'll see. But the culture does need to change. Changing culture of any operation is not easy, but they need to if we're going to ultimately reach the outcome that all of us want and that folks like Abe and Bertola, deserve.
My second question
Yeah.
is,
Oh, sorry. Go. Yeah.
I've heard it more than once, and I'm guessing it might be the most insulting thing that Sick Hanford workers have ever heard, and that is for a WRPS representative to say, there's never
Yep.
During this process, and you also said, Bob, that you don't know what else you could get that would be better than this agreement,
Mhm.
and congratulations. But I think one thing that the workers might want to hear is for them to admit it. And
That's a
to
really good point.
accept
Yeah.
And to be accountable. And anytime in this process,
Yeah.
they finally admit they have been making people sick for decades, or anything close to that.
Then
I can answer that question.
you want to, Tom will take it first. Others may want to weigh in as well, but a fair point first, number one, on your point, right? And Tom?
Yeah. No. No. It's been very difficult. We were gratified that the federal judge, in the decision in the motion to dismiss, pointed out that workers were being exposed and were becoming ill, and said that the record was replete with such examples. So we have judicial notice, but we have more than that, the testimony of many, many workers and their doctors, and independent outside experts that have reviewed the situation. And it has always been a mystery to me why the Department of Energy and the company out there continues to engage in constant denial. One of the very first recommendations in that Savannah River TVAT report, the tank vapor assessment report, was you have to own up to the fact that these vapors are dangerous and have caused, exposures in the past, and they've never done that. So they've never even accepted their own expert review from that. And we're hoping that, there is a new president now at WRPS, Washington River Protection Solutions, taking over from the old president. His name is John Eschenberg. And we're hopeful that new blood in there, a new manager, is going to look at this situation with a fresh perspective and act differently. And, send the word down the ranks. Vapors are dangerous. The toxic chemicals in these vapors can cause injuries and illnesses, and they have in the past. We've got to protect workers against it. Right now, they're kind of going through the motions while saying to their own workforce, yeah, it's really probably not that much of a problem. And yet they don't have the tools to measure these chemicals in the environment. They're not there when these exposures happen in the environment a lot of times. It's been pointed out over and over and over again, and they're stuck on this. So we're hoping what we've got here is an enforceable agreement. So it almost doesn't matter what they want to think or how they act if we can go in and make sure that people are being protected, and at this point in time, they are.
So safe to say it wasn't just an easy sell to get him to sign.
Oh, look, I mean, I'll let them speak to that, but I think the facts of the litigation speak for themselves, right? We were getting close to the eve of trial when it became clear there were serious negotiations going on, at which point we agreed to extend the trial date because we really felt, okay, it does look like there might be an actual agreement coming in place. And I guess just your question, Sienna, I mean, you raise a really important point. Litigation is typically not the place to get an apology, right? So I can't say that we could have gotten that by going to court, but it's certainly fair to say, and I should have acknowledged, right, that by going to court, while we perhaps could not have gained any more from in terms of implementation of technology and all those things, there is a certain accountability that a courtroom presents, where a judge says, hey, somebody's not behaving in a lawful way. To Tom's point, we did hear that in the courtroom that you saw with that federal judge. And that was, when we talked about whether to resolve the case, I can just speak for myself, is, the reason I wanted to go to trial was to have a judge say that. Is it enough to turn down a resolution that we think is the right resolution for workers? Because, but to give that up, it seemed to me pretty clear that we were doing the right thing. And I think the court in earlier decisions acknowledged what was clear, that this was the cause of it. And but that said, in that change to your earlier point, those things are related. A change of culture, I think, can really only happen once the organization acknowledges what they've done. And look, do I think someday that'll happen? I'm not sure I'll live to see it, but a lot of things happen decades after a wrong has been done to a people, right, or a group of people. Sometimes that takes decades before somebody has the guts to stand and say, you know what, we were wrong, what we did. Do I think someday that'll happen? Yes. I'm not confident, frankly, that necessarily, I'll live to see that, but I do think someday that'll happen. I do. The facts are facts are facts, right? Last question?
It's for Meredith and Tom. Since the state cannot pursue financial remuneration for people who are already exposed to the vapors and for their illnesses, either one of your organizations planning on pursuing such reimbursements?
Anything you want to add on that?
Well, I can first say that under the environmental law under which we brought this case, no one can. Yes, under RCRA, no one can receive money for damages. So it's an environmental statute for injunctive relief, and some provisions of it allow for penalties. That wasn't the case in this situation, and it allows for the recovery of the cost of litigation, but it's an environmental statute that seeks to remediate problems. There are other options for individual workers. I'm not taking on any of that at this time. I don't know if Tom or the union wants to speak to that. One of the main focuses of all of these organizations has been to help workers with compensation programs, to be able to get compensation for their illnesses, to have the health care that they need.
So thanks for those questions. Just a final thought for wrap up. We are available for
Could I
questions.
respond to
Oh, yes.
Suzanne Frame's first question?
Absolutely.
Question on culture.
Absolutely. Go right ahead. Go right ahead. Mark's going to be speaking about the earlier question.
Your first question about culture change. And I'd just like to say, we all know that lawsuits and litigation put us into adversarial roles. But with that being said, we have noticed that the department has open lines of communication with our organization. And we're now getting into the room and having conversations with them about issues, more so than I think we have in the past. So I think that's been a cultural shift. And I think it's been beneficial, for us and hopefully for labor in general, that they are willing to now sit down with us and discuss with us the problems, the issues, and try to figure out solutions.
And-
Yes.
Just to follow, I've seen the term nuclear veterans used. Who are the nuclear veterans?
So those are the people that have worked at the Hanford site, and I would imagine the other DOE complex sites throughout the United States, and that's the term of reference that has been applied to them. And as these people retire out that are currently working, I think they too will become the nuclear veterans.
And it is clearly a special service that has come with special risks.
Absolutely. Absolutely. Thank you.
And just a final thought. I mean, you've all asked, I think, really good questions. I think just to that last point, I think it is, look, an agreement was reached. I mean, that says something, right? I don't want to suggest a culture change, but that's the right direction. That's the right step. They didn't have to do it. I'm sure there are elements of this agreement that were not easy for the federal government to sign on to, right? That they have strict obligations and they know we're monitoring those. It may be a small thing. They got to cut a check for almost $1 million, right, to their adversaries in this litigation. That's not an easy. We've all been on the other side of that as litigators. That's not an easy thing to do, and so you even think about what to say at this press conference. I'm mindful that there has been some better communication, right? They did sign the agreement. That's important, and I hope that continues. My team feels the same way. I know that those thoughts you just heard, my team feels the same way. There's been good conversations to reach this deal. So we'll see where it goes from here. I guess just a final thought is that, again, I just want to thank everybody who's here, who's worked so hard on this. I mean, it's been a lot of folks who aren't here who couldn't make it or have retired. I think of folks like Rob Costello, who's a deputy in my office over many AGs, from Chris Gregoire to Rob McKenna and myself, who in those early conversations in our office, Rob was at the table and had some key insights into, possible merits of litigation. I put a call into him earlier this morning. There's all of our organizations have a lot of folks who have been, just putting the time in. And it wasn't, from the beginning, it wasn't, the path is not always so clear when you start out. A lot of folks were critical of the lawsuit. But I can tell you, I was 100% convinced it was the only path for a meaningful change at that point. That everything else had been tried by advocates, by the working men and women. Everything else had been tried. That was the last critical piece. And so So it's a day of optimism. I mean, I think candidly, I think we all feel good about, undoubtedly we feel good about this. And it's our obligation and the obligation of our government to do right by folks like Abe and Bertola and all the workers out there to honor this agreement, to change that culture, and hopefully someday to acknowledge, to your point, Susanna, what has happened in, frankly, a more forthright way. But thanks all for being here. We appreciate the questions, and we'll look forward to chatting one-on-one. Thanks again.